Welcome to the Tribal Child Support Program. This presentation will serve as an overview of the Tribal Child Support Program. We will provide an overview of the Federal Office of Child Support Services and its mission, the key terms of child support, details of the Tribal Child Support Program, program requirements, and key resources that are helpful to review. Let's take a look at the Federal Office of Child Support Services. The Office of Child Support Services, or OCSS, is the federal agency that administers the National Child Support Program for states, territories, and tribes. The Child Support Program was authorized by Title 4D of the Social Security Act. This is why we often refer to the cases in our program as 40 cases, and the program is referred to as the 40 program. OCSS is one of a number of program offices within the Administration for Children and Families, or ACF, which is within the Department of Health and Human Services. Our central office is located in Washington, D.C., with 10 regional offices in Boston, New York, Philadelphia, Atlanta, Chicago, Dallas, Kansas City, Denver, San Francisco, and Seattle. The OCSS mission is to enhance the well-being of children by assuring that assistance in obtaining support, both financial and medical, is available to children. We do this by locating parents, establishing paternity, establishing support obligations, monitoring and enforcing obligations, and dispersing and distributing collections. What is child support? Here are the key terms in child support. Child support is defined as financial support paid by the non-custodial parent to help support a child. Non-custodial parents can voluntarily pay. A court or properly empowered administrative agency, such as a child support program, can order child support, depending on state or tribal laws. The custodial parent is the parent who has legal charge of the child, lives with the child, and who cares for the child's daily needs. This person can also be a relative or other person with legal custody of the child. The non-custodial parent is the parent who does not have primary care, custody, or control of the child, and who may have an obligation to pay child support. More definitions and terms are in our glossary of common child support terms on the OCSS website. Let's talk about the Tribal Child Support Program. Child support legislation allowed Congress to establish the Child Support Services Program under Social Security amendments in 1975. The initial legislation required states to establish their own individual child support collection agencies. Tribes were not included in this legislation. Tribes initially entered into cooperative agreements to carry out child support services, and tribes were allowed to have some say in how services were carried out on their land and with their population. The Personal Responsibility and Work Opportunity Reconciliation Act of 1996, or PERORA, authorized funding for tribal child support programs. No regulations were in place yet, but special improvement project grants were awarded to help tribes collaborate with states to begin tribal child support programs. Consultation was held between 1998 and 2000 before drafting the Notice of Proposed Rulemaking. In 2000, the NPRM, an interim final rule for tribal child support services, was published for tribal child support programs. Comments from the NPRM were considered and incorporated into the final rule issued on March 30th, 2004, granting the ability for federally recognized tribes to apply for and upon approval receive direct funding to operate a child support enforcement program consistent with tribal laws and customs. The tribal regulations balance the tribal flexibility with requirements that result in effective and efficient child support services. In February 2024, the final rule on elimination of the non-federal share was published. Tribal 40 programs no longer have to provide a non-federal share in their annual budget submission. The federal share is now 100% of the tribal child support program cost. The Tribal Child Support Program has grown substantially since 2004. From 9 initial programs in 2004, with 26,000 cases and $12 million in collections, to 60 programs with 53,000 cases and $51 million in collections. As of January 2024, there are 61 comprehensive tribes operating child support programs, and one in startup. Startup is a tribe developing the requirements to operate a tribal child support program. With the elimination of the non-federal share, we've begun to receive more applications and encourage all federally recognized tribes to apply to create a tribal child support program. What does a tribal child support program do? They locate parents, establish paternity, establish support obligations, monitor and enforce obligations, distribute and disperse collections. There are several benefits of a child support program. Child support programs have the benefit of helping engage parents in the lives of their children from a very early age. Can help parents learn how to have healthier relationships with one another and their children, can work carefully with parents who have family violence issues in their lives, and can improve economic stability through referrals to employment, job training programs, and other financial planning services. The aspects of a child support program that are unique to the tribal child support program. Tribes are not required to operate a child support or TANF program. Tribes can incorporate their specific culture and values into the program, and tribal programs are funded 100% by federal dollars. Tribes are required to submit an annual budget, and they do not have to comply with UIFSA like states do, but they must follow the provisions of the Full Faith and Credit for Child Support Orders Act, in which a state or tribe must enforce an order from another state or tribe. And in cases where there's more than one order for the same obligor or child, determine which order to recognize for the purpose of continuing exclusive jurisdiction and enforcement. In tribal child support cases, a non-custodial parent can make non-cash payments, such as firewood, food, or other provisions. Let's take a look at the basics of creating a program and the program requirements. Who is eligible to apply for funding? Any federally recognized American Indian tribe and Alaska Native entity, including tribal organizations designated by 2 or more tribes, can apply. You must have 100 or more children under the age of majority. If a tribe cannot meet this requirement, you can ask for a waiver. And the regulation is referenced here under 45 CFR 309.10. There are 2 phases of funding available, and we'll talk about these phases more in depth in the next few slides. A tribe or tribal organization can apply as a startup program, which allows for 2 years for the tribes to prepare to fully operate a tribal child support program. During the 2 years, tribes work towards revising or adopting tribal code to incorporate the program requirements, develop and adopt policies and procedures, and hire and train staff. If you're interested in applying to become a startup program, we encourage you to look at your current human service policies and procedures and analyze what work will need to be done to incorporate a tribal child support program. IM 2401 provides guidance on writing the application and program development plan. And of course, our regional offices are always able and willing to meet with you to discuss your interest and help you through the process. Tribes are required to submit a budget. The funding is limited to $500,000 over a 2-year period with a no-cost extension allowed if more than 2 years is required for the startup program. Upon the 2nd year during the startup, the tribe will submit the annual budget and progress report and report expenditures using the SF 425. During the startup phase, tribes will be working towards finishing policies and procedures and other items needed for operation of a comprehensive program. After submitting the comprehensive program application, OCSS will review the application, provide feedback if necessary, and approve, which will include approval of the tribe's child support program plan. Funding for comprehensive programs is done annually via the annual budget submission. Programs are required to complete quarterly and annual reporting documents. See these regulations and policy documents for more detailed information and guidance. When a startup program submits their proposed budget, the budget must only include allowable costs, which are costs that are necessary for developing the tribal child support program. Costs can be related to developing laws, policies and procedures, training, office equipment, and child support staff salaries. These regulations will provide additional information. And remember that all expenditures are subject to the uniform grant and audit requirements in the 45 CFR Part 75. Costs that are not allowed to be charged to the grant per 45 CFR 309.155 are activities related to other programs, construction and major renovations, reimbursed fees or costs, jailing parents, legal counsel for non-custodial parents or guardians ad litem, and costs that are deemed not reasonable, necessary, or allocable for the operation of a tribal child support program. As mentioned before, the final rule of the Tribal Child Support Enforcement Program was published in the Federal Register on March 30th, 2004. The rule sets forth the required elements and related provisions for tribal child support programs. We'll spend the next few slides reviewing the requirements. 45 CFR 309.65A provides a complete description of the 14 requirements. All comprehensive programs must comply with the 14 requirements. Startup programs must detail via a program development plan how they plan to come into compliance with each requirement. On this first slide, we have population description, application process, due process protections, administrative and management procedures, safeguarding of child support data. On this slide, record maintenance, tribal laws and regulations for child support, locating NCPs, paternity establishment, and guidelines. And finally, income withholding, distribution, intergovernmental case processing, and tribally determined performance targets. Federal tax refund offset, administrative offset, passport denial, federal parent locator services are all optional enforcement remedies that can be explored and incorporated into a tribal child support program. Many tribes use a combination of automated office applications and manual processes to perform case management functions in child support cases. Some tribes use the state's computer system, and others use commercial case management software for processing child support cases. All child support programs are responsible for maintaining an accurate case inventory, documenting case actions and collections and disbursements. During the startup phase, consider how you want to manage your case information. As part of the terms and conditions of receiving federal funds, tribal child support programs are required to submit federal reporting forms. The standard form 425, SF 425, is a federal financial report for reporting program expenditures. The OCSS 75 is an annual data report form reporting data such as caseload, and the OCSS 34 is the quarterly collection report form reporting the amount of child support collections. Here are the related references and policy documents for information on becoming a child support program. And here are the resources. Please check out our website for all of our Tribal Child Support Program documents, including the Tribal Director's Guide, guidance on the startup application process, Child Support 101, and current Tribal Child Support Agency contacts. You can always contact us at ocss.tribal@acf.hhs.gov for any questions. And thank you to National Tribal Child Support Association and National Association of Tribal Child Support Directors for being great partners.